This is the first screenshot video for weeks 5 to 6 in the civil practice course. I have referenced in the setup for these 2 weeks pages 9 through I believe it's 12 of the textual outline, and I have page 9 up now on the screen. It's referring to federal courts. And in this video, we're going to do 2 things, I hope. Number one, just take a look at how the federal courts generally are organized. And then secondly, we're going to take a look at what types of cases can be handled, what types of civil cases can be handled in the federal courts. And a fancier way of saying that is, what is the subject matter jurisdiction of federal courts? First, the federal courts. And I start out with the Supreme Court, but let me go from the bottom up. So if I can find it, here we go. We have our district courts. And those federal district courts are really the entry-level courts in the federal system. That's why I wanted to start with them. And we have 94 federal judicial districts. We have at least 1 district in each state, as well as in the District of Columbia and Puerto Rico. I would note that each district court has a U.S. bankruptcy court part, and then there are territories that have district courts, etc. Here in New York, we have 4 federal district courts because of the population of the state. Downstate, we have the Southern District and the Eastern District. The Northern District encompasses Syracuse and the northern part of the state. And in Buffalo, we are in the Western District, or if you will, we could say the courthouse in federal courthouse in downtown Buffalo houses the United States District Court for the Western District of New York. And then when we move up the ladder, we have U.S. Court of Appeals, and those would be the courts where we're taking appeals from the district courts. And we had 94 judicial districts, but they're organized into 12 regional circuits, each of which has then a U.S. Court of Appeals. And we here in Western New York, actually in the state of New York, are in the 2nd regional circuit, or if you will, the 2nd Circuit Court of Appeals, which is headquartered in New York City. So we like appeals to that court because then we get to spend a day or two in New York City, courtesy of our client, we hope. And then as we finally go up the ladder, we have the highest court in the federal system, the Supreme Court of the U.S., which of course is in the capital city in Washington, D.C. And the U.S. Supreme Court, by the way, can also hear cases coming up from the state court system if we were on the constitutional side of things. But just understand then that we've got U.S. district courts, entry level, first level appeal or intermediate appellate court, the U.S. Circuit Court of Appeals, and then at the top the Supreme Court of the U.S. And I have a little daily federal courts relevant to Erie County. So our local, I'm repeating myself, I know, but the local federal district court is a district court for Western District of New York, and then appeals from this court are taken to the U.S. Court of Appeals for the 2nd Circuit. Next, we ask ourselves, well, what types of civil cases are handled by the federal courts, and as I said, we can call that the subject matter jurisdiction of federal courts. And when we look at the subject matter jurisdiction of federal courts, we see that the Constitution, the U.S. Constitution itself, in Article 3, Section 2, I'll leave that for the legal advocacy course, but it sets forth what I've described as the constitutional boundaries for federal subject matter jurisdiction. And in the civil area, the two most important categories and the ones we're going to talk about are federal question jurisdiction and diversity jurisdiction. And at this point, let me just repeat something that we've mentioned earlier, and that I know I mentioned in the introductory course as well. In the U.S., we could say that on the one hand, we have state law, or the laws of the various states. So there are New York state laws, by way of example, the New York State penal law. And on the other hand, we have federal laws. We have, for example, a whole wide variety of federal laws that prohibit various types of discrimination in employment practices. So if you tell me that there's a law and give me enough time, I'm going to tell you whether it's a federal law or whether it's a state law. When we talk about state law, two areas that are going to be commonly the object of a lawsuit would be the law of torts and the law of contracts. So in New York State, by way of example, if you see a car accident and someone receives a serious injury and they're going to bring a lawsuit against the other driver, the lawsuit will be based on what we call the tort of negligence, and that is a claim then that would be raised under the state law of New York. If someone comes into our hypothetical law firm and claims that they were terminated from their employment because of their race or because of their gender, broadly defined to include gender identity, or perhaps they were terminated because there was a perception that they had a disability, or in fact they have a disability, but they could have continued to work had it been reasonably accommodated, and so on. We're looking there at federal law. So when I begin by saying federal question jurisdiction, what we're saying is that federal courts have subject matter jurisdiction in all civil actions arising under the Constitution of the U.S., the laws of the U.S., or treaties of the U.S. So when we look at what happened after the November 2020 presidential election, you may remember that there was any number of lawsuits brought to challenge the election. And not all of those lawsuits, but most of them were brought under a claim that some federal law, either a law enacted by Congress regarding voting, or perhaps the Constitution itself. There were some claims raised under the Equal Protection Clause. Those cases, if you may remember, were brought in federal court most of the time, and of course federal court had jurisdiction to handle the cases because the claims arose under federal law. One point I want to make, however, and it's a footnote number 1, is that most federal question cases, except for a few like copyright disputes, patent disputes, and bankruptcy court disputes, can also be heard in state courts. But typically, I think if we counted up percentages, that the largest, by far the largest percentage would be cases brought in federal court. And indeed, it was in a federal court in a lawsuit challenging the results of the election in Pennsylvania that one of the lawyers representing the former president of the U.S. Expressed a profound lack of knowledge of the Equal Protection Clause. But that was where the claim arose, and so it properly was in federal court. Now we have something that may be a little bit surprising to some of you, though I've tried to hammer this home when I've talked about the Buffalo Creek disaster, and that's diversity jurisdiction. And if we've got the plaintiff and defendant from different states, and if the amount in controversy is in excess of $75,000, and by the way, Congress sets that amount. When I first started learning federal law in federal jurisdiction years and years and years ago, the amount was $10,000. So you can see how long I've been around it and how significantly the amount has gone up. I guess part of that, is inflation. But in any event, if there's a claim under state law, and the plaintiff is from one state and the defendant is from another state, Article 3, Section 2 of the Constitution, and then the congressional statutes creating jurisdiction consistent with Article 3, Section 2, permits that case to be brought in federal court. And of course, that gets us to what happened in Buffalo Creek disaster. If you remember, the plaintiff's attorney wanted to bring his claim in federal court. He just didn't feel comfortable bringing the case in West Virginia State Court, believing perhaps reasonably that the mining interest probably had a lot of influence in those courts and the judges who were elected to those courts. Remember, the federal judges are appointed for life, so you don't have the political sway perhaps as you do in some state court systems. In any event, he wanted to bring his case in federal court, but he felt that the best claim he had was under the tort law of West Virginia. So he had a state law claim, and he wanted to bring it in federal court. The plaintiffs obviously were all West Virginia residents because they were living on the Buffalo Creek when the catastrophic flood event occurred. The owner of the mining company that permitted the condition, negligently permitted the condition to exist where we had this catastrophic flood, was a West Virginia corporation. So Gerald Stern was stymied in bringing the case in federal court, except by his ability to argue that the West Virginia corporation, Buffalo Mining, was actually controlled by its sole owner, the New York corporation Pittston Company. So it was his ability to pierce the corporate veil that permitted him to bring the case in federal court. It was a state law claim, but he had diversity, plaintiffs West Virginia, defendant New York. In our next video, we're going to talk about something called removal jurisdiction, but this will complete this video.